Okay, pleased to see you again in the second session of this class. So, actually, the Congress is principal authority to organize the frame of a public bureaucracy is considered, and also I mentioned that the Supreme Court is very important and determinative about specific cases. So opulence of a institution and system has been progress of history, you consider, and I said that the Civil Service Reform Act of 1983 is important. About a termination hearing involving the public employees, and two-tier system was instituted in the act, and actually the practical consequences three-tier system of review about the termination. So we consider, for example, if the pre-termination hearing is indispensable from the demand of a constitution and others, what is the third picture in this projection? It indicates the logo from U.S. Merit Systems Protection Board, and the board is carrying the statutory duty, and what is that? And the administrative judges or board members of this institution are competent in some exceptions to hear the legality of dismissal of public employees and others. So the kind of institution now often considered as settled about the rank and grade system of a bureaucracy and a senior system as insulated from political influence, and now considered the kind of element required in the law of public employment. So, how much are you concerned about the bureaucracies? Actually, the institution is quite pivotal to sustain the capitalism and the government system you consider. And how do you perceive the goodness of a big government, bureaucracies? And you now consider, for example, international organization, what we may say another distinction, which is stronger in flavor. I'm not sure if it deserves that entitlement. What international government? Politically, we see no international context of government. We rather prefer to use the word governance or organizations, international. So you now expand the scope of a post. Now, many international organizations are hiring the public employees, and many posts were created. How do you consider the unemployment problem of nations? And many posts are filled by from the developed countries, and IMF, the WTO, United Nations, and many they launch as to for job vacancies, for example. And now Korean users may apply for the post of international government. That context may be compared with the increase of national bureaucracies. So actually, a bureaucratic sociology will not be negatory amnesty, to be honest. And actually, some system about justice of this internal matters is highly demanding. How do you see it plausible if we consider it kind of a property concept as framed by Yale Law professor Charles Wright? And we'll come back later about cases illustrated in this projection for more deliberation. And I now may advance the first topics, which should be brief. And consider, for example, the global issues as related to public policy. I've once experienced some interesting work, which is titled "How do International Institutions Matter? The Domestic Impact of International Rules and Norms." It was from Professor Cotel, University of Utah, and James Davis, University of Munich. And in that article, the professors argue that there is two important elements we need to make a point: salient of norms and salience of a domestic political context, which affects the extent of influence of international matters in the domestic policy making. The professors contrasted two illustrations, historically which has historical implication in this area of concern, the Japanese semiconductor industry in 1980s in the United States. That is commercial matters. And Reagan administration had responded a little lately from the trajectory of events. So in 1986, the occupancy of domestic market by Japanese semiconductor industries have been conspicuous. But it is not actually alter the basic share of a domestic market. Still, the United States semiconductor industries has a hold in domestic market dominance. So the situation has aggravated over development of that competition, and arriving at 1989, 6 years later, the domestic market actually was saturated with a Japanese semiconductors. And then the Reagan administration has initiated to launch a negotiation and the kind of a trade, many available tools in terms of public policy making, network, and also negotiation, the kind of a bipolar treaties, and what is that? A orderly market agreement, the kind of a voluntary export restraints, and a new protectionism in terms of a public policy some new words to coin the U.S. practices in 1980s were pursued, and to settle the case in the interest of national commerce. And the response was proven to be effective eventually. However, it was lacked. And the point of contrast may be drawn on the intervention into Iraqi war in 1990s, and during the reign of a Bush administration, and the response fairly ready, and what actually required a short-term period to advance to any action or resolution, the kind of a enforcement to redress the justice of international peace was fairly instantaneous in that. So what makes it as different in the terms of professor viewpoint? The salience of domestic norms and the structure of domestic policy making are factors to produce a different response based on issue basis. So the professors framed into four meaningful boxes, for example, in furtherance of your understanding, as you see later in the printouts delivered, what is structure of a decision making in the domestic context, and also the closeness. How much does it close? The domestic decision making process is on response. So the issue might be more appealing to what actually facilitate the progress of policy outcome, and the national resolution may be expedited in the initiative calls about the characteristic emergent war and a foreign policy, and the professors employed a process tracing to reveal the dynamic of a domestic policy making, how Reagan administration did intact with Congress, and what are the alternatives and any positions of a Bush administration in effective dealing of the national cause, about in some cases they might negotiate and some forego some to effectively address the challenges of war, and how do you consider the context of UN resolution? Actually, now I have mentioned about the international organization in terms of bureaucracy and all this. Do you consider the national context of bureaucratic pastorality is also present in the international organization? Actually, many complicacies and some distinct elements are now in combination to produce what expose the reality of our living in the global context. And I may see in some aspect that the kind of a symbolism may be a factor to address the contemporary issues. Since we are now in a global context, we once launched a campaign to host the 1988 Olympic Games. We successfully got through the bidding, and have upgraded our status in the international community and to forge our impression. How do you consider the role of public policymakers and administrators in achieving that success? I also consider in counter-thesis, for example, the normative, political, economic logic or narratives against this kind of symbolism. Often we may have some awareness that the element could be shared, but in the initiative or final responsibility, the hegemonic power often prefers to seek the basis about public policy in the springs of a normative, a political, and economic justification. The U.S. would be notable since they all and what is that? Of course, it also come into our consideration that the realist viewpoint of politics is quite consequential through the global issues, and that could be another point of concern I consider. But the public policymakers, it is actually quite required when we evaluate the talent or quality of a policymakers or administrative agencies in assessing global issues and contextualize the development into any meaningful domestic policymaking. Kind of symbolism, for example, may to increase the national interest. The institution of Nobel Prize, for example, is quite striking to elevate the national prestige of Sweden and make it an appealing point in the interest of a Swedish politics. I also read a very interesting ads from British government, and what are 6 fundamental questions now posed to seek any meaningful solution, antibiotic, dementia, water shortage, air flight, decent air flight, without harming the environment, and paralysis. That is actually kind of a stigma now the global populace have often share in concern. So it is similar to the Nobel Prize. It's innovative to create a public attention for the British politics. So policymakers, of course, including diplomats and others, could have some sagacity, wisdom, or the kind of acumen to penetrate the issues. The kind of symbolism is rooted in philosophical, human philosophy or social philosophy. Also, you see a point of distinction about public organization in France. You may travel the museum, Louvre Museum, or in Palace of Versailles. That is an important source of income for national interest. And the public administration in France now have some distinct leverage of a bureaucracy. They made a focus to increase the profit or income by utilizing the cultural assets, and the title of office, whereas may be flexible to reflect the responsibility. Quite interesting. Of course, that should produce a public good. That kind of symbolism might be related with the fundamentalism in some cases. How do you consider the kind of a philosophical drive? It might be failed in some cases. It must be avoided. As we agree, for example, the kind of the attack, terrorism might get construed in that, which is actually an evil side of what is ground zero. WTO buildings is earn any merit to be attacked. So the public policy need to solve actually welfare and the goodness of a society, community. And I forgot to bring the rest of materials about this matter. That will be available later in this class, perhaps Thursday. Okay, then we revert to the topic delivered in the fourth session. So, the Pendleton Act and Lloyd-Lafley Act of 1913 would not be a big leap, but actually make an effect and thought-provoking, leading to the subsequent legislation and court frames in development, I consider. Neither the Pendleton Act nor the Lloyd-Lafley Act seriously addressed the full range of issues that may surround the decision to terminate an employee. This is because a common law, one's possession of a job, including a job with the government, constitutes a privilege, not a constitutionally protected right. For purpose, the simplest way to conceive of a legal privilege is to assume that it exists only to the extent the contract creates it. In the field of employment, a worker would have the privilege of working for the government only to the extent a legally binding contract would obligate the government to pay the employee for his or her work. So, actually, I mentioned the Equal Pay Act and was the comparable was theory, which is the most advanced in this period. However, also you now recall on the cost and benefit analysis or others. So the court would not be so positive, rather reluctant to agree on any active consequence. It is actually cumbersome for the courts to render any positive engagement, to call upon any positive engagements about pay increase or others. So the judiciary in this area of law is not a proper forum to contend, oftentimes. So the nurses in the University of Washington could not represent the cases in the litigation. So they may raise a claim, for example, why are we afforded a lower pay, lower compensation? From kind of other disciplines, social department, professors of social work, for example, and professors of nutritional science. How do you evaluate that assertion? In the field of employment, a worker would have the privilege of working for the government, but as I said, on the contractual basis. So I have introduced the concept at-will doctrine in the basics of employment law. And unionism would also be considered in this context. So as I elicited the area of a public administration involves the historical points of distinction about American legal system, of familial relations, and school relationships, and union relationships. So, how do you perceive it pure or impractical, virtually over area of concern, the dichotomy between private and public, and others, national or international? Now, a mosaic of evolution identified through the practice and lessons and reforms and others. However, still we may have reverberation, some orthodoxy, for example, about a law of public employment. I have mentioned of the law of affirmative action. Affirmative action employment policies are often misunderstood. Many programs seek no more than to equalize racial or sexual balance in employment, where occupational tasks have little or no predictive power on job performance. Is there any legal or moral objection to such programs? What principles of justice, if any, support such affirmative action policies? And we also consider the practice of recruitment. Consider. And I've once pointed out pros and cons about affirmative action in public employment. The agenda or issues may be more properly responded by the officers of same attribute. The affairs of Indian tribes may be resolved more effectively if we use the workforce of that enclave and others. So many elements actually involved. Reflect, for example, on the social justice implications of affirmative action with reference to the political series of individual liberty, equality of opportunity, and the Marxist credo from each according to his abilities and to each according to his needs. So what are merit systems protection board in that point of deliberation? How do you consider it could be any permanent repercussion between social and liberal philosophy? I also further a little bit on the Ross and Sinderman cases. In Hindu side, they look like the proverbial cabinet noses on the tent. What is this proverb meaning? So they hardly stand as a ringing endorsement of the right of due process in the employment context, but they suggest the employees deserve protection for some constitutional rights on the job. This holding naturally steers lawyers who represented fire public workers to the argument that the job itself is a form of property right protected by due process. We also see one transitional case in 1976, which is Bishop versus Wood. In that case, the Supreme Court upheld firing a police officer without a due process determination hearing in the following circumstances. Officer Bishop, having completed first probationary year of employment for the city of Marion, North Carolina, was by Marion City Ordinance considered a tenured. So, then you can find any property right in this situation. The ordinance stated that he could only be fired for cause, and the cause is specified in the policy, all related to the failure of an employee to perform the job properly. The court majority held that since no public explanation for the firing was given, no hearing was necessary. So the parallel is very persistent as we considered in our laws. So stated reason might be given. Then do you agree the court would see high chances about some process due in the Constitution? But on close analysis, the argument falls apart. If the city could fire him only for failing to do his job properly, then the firing itself is a public review, one that would damage his liberty and property interest in gaining employment elsewhere. And if instead he were wrongly fired, is there not an additional reason to grant the worker some kind of due process hearing? So we now cherish the judiciary as a champion of a liberty and property. So it generally considered to represent the liberal democracy or constitutionalism. So the property or liberty concept could be placed at the center of contention oftentimes, and assume if the property right is actually the product of a public consensus. Do you agree? Would that be leftist advances? How much do you find, for example, so later, as seen in the class discussion, the legislature is actually empowered to authorize the scheme of a property right in this narrow term of public employment, of course. So the procedure would be essential whether the dismissed workers or employees could recover. And that is also the case. Oftentimes we witness in the process of a civil litigation or others, and the leeways would remain amply in the hands and initiative of legislature. How to frame the procedure that would critically operate to shape the essence of that controversy. So the legislature can come more salient about this matter, and the context could be determined and meaningfully considered. I have illustrated the Civil Service Reform Act of 1978. It provides an illustration of this trend. So now more affordable institution was created to protect the rights of public employees about dismissal or termination. Section 7513 of the Act requires that an employee who is to be removed, suspended for more than 14 days, reduced in pay or grade, or laid off for 30 days or less be provided with certain protections at the agency level. So specifically, the employee is entitled to at least 30 days advance written notice, setting forth the reasons for the action. The requirement is waived if the employee is believed to have committed crime for which imprisonment is possible punishment. Not less than 7 days to answer the charges orally and or in writing, to include the submission of affidavits or other documentary evidence, the representation by an attorney or other person, for receipt of written decision and the reasons for it at the earliest practicable date. So I have stated the patronage dismissal about the public employment relationships. Later you see how do you consider, for example, the sweeping officers of sweeping pass winning party would make a massive dismissal of the subsidiaries. Here should be Expedia about the plenary power of personal affairs, and they could advance permissibly to lay off many officers in practical position, others who has a political beliefs of opposing parties or affiliation in that kind. Of course, that could be viewed in strengths about the public administration. So that might be essential to ensure loyalty and faith for the prevailing policies of prevailing parties. So that is also the theory and assumption that the democratic form of government operates. But do you disagree if the insubordination or other disloyal conduct would not be present? Actually, might be expectable, but not occurred any concretely. So how do you dare to dismiss and enforce the kind of anomaly or massive layoffs? Additionally, at the discretion of the agency, the employee may be afforded a hearing in place of or in addition to Provision 2. And the second type of process described in Section 7701 of the Act begins with the employee's statutory creative right to appeal the decision of the agency under the procedure listed to the Merit System Protection Board. So that also could be appealed to the Court of Review. So that then we have three types of a review system about a unlawful discharge. In addition to these statutory protections, the Supreme Court itself has moved away from the logic of Bishop. Here are two cases that describe the employee's due process property right to hearing. Pay attention to the court's interpretation of the relationship between the substantive aspect of employment as a property right and the procedural requirements for protecting that right. Prior to road mill, the court had reasoned the property rights are defined by and conditioned on the legislative choice of procedure when those rights are to be terminated. In Annette, the court said where the grant of a substantive right is inextricably intertwined with the limitations on the procedure which are to be employed in determining the right, a litigant in the position of appellee must take the bitter with the sweet. So actually, the tendency of code could be on vogue, not well settled. But we also see some consistency about the basics of laws. So policy frames may vary in specific deals, which is, of course, on case-by-case basis. By linking the scope of procedural protection to the substantive nature of property interest, legislature could erode the value of entitlements simply by specifying limited procedural protection for termination of employment. In Loudermill, the core majority rejects this theory and forms a constitutional due process requirement for statutory entitlements. So you will see in the printout two cases I stated. Cleveland Board of Education versus Loudermill, and Gilbert et al. Versus Homer. We'll be helped out if we have some brief of summary about this case. When he filed out a job application to become a security guard with the Cleveland Board of Education in 1979, James Loudermill indicated he had never been convicted of felony. In 1981, he was fired after the board discovered that he had been convicted of grand larceny in 1986. Loudermill was not afforded an opportunity to respond to the charge of dishonesty or to challenge his dismissal. Loudermill filed an appeal with the Cleveland Civil Service Commission, stating that he thought his 1968 conviction was for a misdemeanor, not a felony. So perhaps the ignorance of law might occur in his person. The hearing referee recommended he be reinstated, but after hearing argument, the full commission upheld his dismissal. Loudermill filed suit in federal court alleging that the Ohio law was unconstitutional, because it did not provide public employees with an opportunity to respond to charges against them prior to dismissal, and thereby deprived him of property without due process of law. The district court denied his claim. However, the Court of Appeals for the Sixth Circuit reversed. The Supreme Court granted certiorari. In this case, the Supreme Court concluded that all the process that is due is provided by a pre-termination opportunity to respond, coupled with a post-determination dismissal procedure as provided by the Ohio statute. Because respondents alleged in their complaints that they had no chance to respond, the district court in dismissing for failure to state a claim. The judgment of the Court of Appeals is affirmed, and the case is remanded for further proceedings consistent with this opinion. And you now be presented about a brief of facts in Gilbert versus Homer. On August 26, 1992, while employed as a policeman at East Stroudsburg University, a Pennsylvania state institution, Richard Homer was arrested and charged with felony drug possession. ESU officials suspended him without pay, effective immediately, pending their own investigation. Although the criminal charges were dismissed on September 1st, its suspension remained in effect. So, actually harsh through the undetermined period of time, so no pay, and some ways to recover his interest. On September 18th, Homer was provided the opportunity to tell his side of the story to ESU officials. He was then reinstated, but demoted to groundskeeper. He filed a lawsuit under pertinent statute, 42 U.S.C. 1983, claiming that ESU President Gilbert's failure to provide him with notice and a hearing before suspending him without pay violate his constitutional due process right. So, how do you appreciate the ambit of a due process of law? So, I've introduced the Matthew Doctrine, which is actually foundational about this area of concern. Three factors need to be distinct in applying the law, the doctrine. First, the private interest that will be affected by the official action. Second, the risk of an erroneous deprivation of such interest through the procedure used, and the probable value, if any, of additional or substitute procedural safeguards. And finally, the government's interest. So, the last factor in the Matthews balancing, and the factor most important to resolution of this case, is the risk of erroneous deprivation and the likely value of any additional procedures. Petitioners argue that any pre-suspension hearing would have been worthless because, pursuant to an executive order of the governor of Pennsylvania, a state employee is automatically to be suspended without pay as soon as practicable after being formally charged with a felony. So in this case, the judgment of Court of Appeals is reversed. Although the charges against respondent were dropped on September 1st, It did not receive any sort of hearing until September 18th. Once the charges were dropped, the risk of erroneous deprivation increased substantially, and as petitioners conceded an oral argument, there was likely value in holding a prompt hearing. Because neither the Court of Appeals nor the District Court addressed whether, under particular facts of this case, petitioners violated due process by failing to provide a sufficient prompt post-suspension hearing, we will not consider this issue in the first instance, but remain for considerations by the Court of Appeal. And I also addressed briefly the substantive elements about public employment law, freedom of political expression and right to privacy. Perry and Road Mill is a pioneering case, and the court's protection of political freedom reached further in Elliott versus Barnes. Here, where Democrat defeated a Republican to be sheriff of Cook County, Illinois, he fired all other sheriff's deputies who refused to join the Democratic Party or otherwise support the party. So we often call it a patronary dismissals, as I've introduced. How do you perceive the prevalence of this practice in the Republic of Korea? Often we consider it as one of ethics, government ethics, to make the public arrangement neutral and actually impartial, and that would consider a sovereign goal about organizing act or other executive orders, a subsidiary context of a decrees, and so audacious to execute a patriot dismissal at massive extent. How much do you see it impeccable, auspicious for democratic basis of offices? Patronary practice falls squarely within the prohibitions. In the practice, public employees hold their jobs on the condition that they provide in some acceptable manner support for the favored political party. The threat of dismissal for failure to provide that support unquestionably inhibits protected belief and association. So this aspect concern of a political status, or constitutional status, expressly in the Republic of Korea and implied in the context of United States. I illustrated the right to privacy or other innumerable rights. The Korean Constitution has expressed provision about protected belief and conscience. A popular frame about the right to conscience, which includes the conscientious dissent against the war, freedom to belief and conscience, and right to association, assembly. It actually comes into ambit of First Amendment right or innumerable rights, and some provisions pronounced in the Korean Constitution. Dismissal for failure to provide support only penalize its exercise, the belief and association, which government may not ordain directly or achieve by indirection. And regardless of how even-handedly these restraints may operate in the long run, if the political office had changed hands several times, protected interests are still infringed, and thus the violation remains. Although the practice of patronage dismissals clearly infringe First Amendment interests, our inquiry is not an end, for the prohibition on encroachment of First Amendment protections is not absolute. Restraints are permitted for appropriate reasons. So, what are interests that offer a justification of a patronage dismissal? Well, perhaps there would be the need to ensure effective government and the efficiency of a public employee. It is argued that employees of political persuasions are not the same as that a party in control of a public office will not have the incentive to work effectively and may even be motivated to subvert the incumbent administration's efforts to govern effectively. Are you persuaded? The court would not be persuaded. And do you find any disincentive? In contrast, if they are affiliated with opposing parties, how much do you expect that context could come into reality? The inefficiency resulting from the wholesale replacement of large numbers of public employees every time political office changes hands belies this justification. And the prospect of dismissal after an election in which the incumbent party has lost is only a disincentive to good work, for it is not clear that dismissal in order to make room for a patronage appointment will result in replacement by a person more qualified to the job, since appointment often occurs in exchange for the delivery of both or other party service, not job capability. More fundamentally, however, the argument does not succeed because it is doubtful that the mere difference of political persuasion motivates poor performance, nor do we think it legitimately may be used as a basis for imputing such behavior. So, as I've said, we need to reflect in balance about other context of a consequence, insubordination or poor job performance. In this case, is merely expectable, not brought any concrete ground, as I said. Well, a second interest advanced in support of patronage is the need for political loyalty of employees, not to the end that effectiveness and efficiency be ensured, but to the end that representative government not be undercut by tactics obstructing the implementation of policies of the new administration, policies presumably sanctioned by the electorate. This justification is not without force, but it's nevertheless inadequate to validate a patronage wholesale. I expect you agree. Limiting patronage dismissals to policy-making positions is sufficient to achieve this governmental end. It might bring a sweeping effect through the terminal of offices and the offices on non-policy-making individuals will not see any ground to be dismissed. And they have only limited responsibility and therefore not in a position to support the goals of the party, of the in-party. So actually, the court would investigate seriously through the details of context and points of a service and disservice from the pattern of dismissal. And often there is a dominant style now which prevails over a common law jurisdictions, jurors of common law jurisdiction. So we find laws significant. Typically, we may find the phrases and words in the holdings of court of in the holdings and court opinion, and also you may now be available of what is a anti-discrimination law. For example, consider the activism from the National Association for the Advancement of Colored People. In some cases, the organization may employ the kind of tactics about negotiation and settlement. I have illustrated the affirmative action for which is scheme to restore a justice, a past two wrongs and the concept, and there are many elements you now need to consider: evil motive or a differential treatment, and disparate impact, as I've said. Consider Ms. Taxman's case in Piscataway Township Board of Education versus Sharon Taxman, decided in 1997. The school board eventually accepted the settlement as an alternative to costly litigation. And so too did Ms. Taxman, who was primarily interested in compensation. The school board paid 30% of the settlement, while civil rights groups paid the remaining 70% of the 433.500 settlement. And one other discrete group in the context of a public employment would be veterans. And there are many laws about a favorable treatment about this group, so executive orders, and most importantly, Title 7 of the Civil Rights Act. The Constitution, through the post-Civil War Amendment, speaks more specifically to the evils of racial discrimination than to other forms of discrimination. But the later context of evaluation will be extended. Is consider veterans and female workers or workers from Indian tribes. Like the civil rights movement, the women's movement has sought to eradicate discrimination against women in the workplace by using litigation and building on the anti-discrimination provisions in Title VII of the Civil Rights Act. So, for example, consider about the second element, differential treatment between female and male workers who are retarded about reporting to the workplace or others. Female employee in that hypothetical situation may be fired more readily for being late to work too often. But male workers with similar tardiness records are not fired. How do you find injustice in this case? Differential treatment takes place when, in similar circumstances, people in one class are treated differently from people in a separate class. Proof of differential treatment usually requires the plaintiff to present statistical information about comparative employment decisions and patterns. Such investigations can, of course, be very time-consuming and costly. And I have enlisted the nursing faculty of a University of Washington and the tenet of comparable words, which actually cumbersome to be reduced into any fine form of a judicial complaint. You consider. And in your printout, you find some practical documents which shows hypothetically the legal complaint. So legal battle against discrimination seems far from one. So we need to practice introduction parties and the plaintiffs and the defendant. The plaintiffs are treated unequally. Consider Dr. Nabadowling or Dr. Oda. So some worse paid professors would be interested in this practical document, I consider. But the court rejected the claim. So new form of a cause of action. So also we would very reminiscence about the past paradigm between active government and the conservative judiciary. So often the cost and benefit analysis, and what are those? Fiscal capabilities of state would pose limitations. Place well the limitations in this aspect of dealings. So I've said this position of Ninth Circuit of Appeals about nursing faculty. Well, how do you consider it falls within any comparable work, such as faculty in health services, social work, architecture, urban planning, environmental health, speech and healing, rehabilitative medicine, and pharmacy practice? Why do nursing faculty suffer from lower pay? Same comparable words. What do you see any reason, if available, from the court position rejecting this argument? So do you consider it fairly adequate if we term the judicial branch as conservative, or as passive, neutral, and impartial, but often reluctant to take a remarked leap or about the progressive reform? That should perhaps fall within the responsibility of political branches, Congress, executive branch, the faculty, or the Board of Regents of public universities. Okay, that will be all for this class. Thank you for your attention. For the rest of issue, we will be further on that in the next class. Okay, see you in the next class.